So according to Brisbin v. Schauer, Brisbane v. Schauer, 1971 Supreme Court case, Colorado. So this is for the judicial branch of Colorado. Where a jury trial is granted, the right to a fair and impartial jury is a constitutional right which can never be abrogated. That comes from Groppe v. Wisconsin, but they're going to say that that's a holding for this case too. Brisbane v. Schauer, 1971, you're allowed to have a jury trial, or a jury trial has been granted, then you have a right to a fair and impartial jury. If you have a right to a jury trial, you can't have a biased jury or a biased judge. And it can never be abrogated, according to Groppe v. Wisconsin. Also, 6th Amendment, 14th Amendment, Colorado Constitution, Article 2, Section 16 and 23. Section 16 and 23. I'm going to say 16 is the right of the criminally accused. I thought 23 is the right to a grand jury. So that's the big holding for Brisbane v. Schauer, 1971. Let's talk a little bit about the case, okay? So you have Robert Lee Brisbane versus Hilbert Schauer, who is the executive director of the Colorado State Department of Institutions. So you already got this guy who's already been convicted. He's been convicted with murder in the first degree. No, hold on. Let me take a step back. Chief Justice Pringle is going to be the one that issues the opinion. So this is a Pringle opinion, December 27th, 1971. The rehearing was denied. William L. Lloyd for Pueblo for the petitioner. Duke W. Dunbar, Attorney General. Okay, so Robert Lee Brisbane was charged with murder in the first degree. That's with deliberation. They should have done the second degree too. So was it knowingly with deliberation? Now Robert Lee Brisbane is going to do the same shit as this Audrey Psycho Burroughs. He's going to say he's not guilty by reason of insanity. He was tried to the court and he was found not guilty by reason of insanity at the time of the alleged commission of the crime. Now, there is such a thing as temporary insanity, isn't there? Now, this Robert Lee Brisbane is going to be committed to the Colorado State Hospital at Pueblo. Oh, my God. So he got him. He fucking got him. Right? Robert Lee Brisbane probably just straight up murdered somebody. And then some fucking slick-ass lawyer comes in and says, okay, just plead not guilty by reason of insanity. Which, if you listen to it, you're not guilty because you was crazy when you committed the crime. So you're saying you committed the crime. It's not saying that you're not guilty. It's saying that you're guilty, but that it's okay because you're crazy. Hey, you're crazy, so it's cool. 6 months later, in December 1969, appellant filed a petition for a writ of habeas corpus asking the Montezuma County District Court to determine if he was entitled to discharge or conditional release. Oh my fucking God. So the slick lawyer keeps his shit up. The court issued the writ. The return was filed January 1970. Appellant filed a motion for a change of venue. So they said, okay, fine, we'll listen to the fucking thing. And then he's like, oh, I can't get a fucking fair, So he got the petition for a writ of habeas corpus. And then he says a change of venue. And then the judge is going to say, well, you can't do a change of venue on top of a writ of habeas corpus, a motion. You can't just... And he's probably right about that, but ultimately, you can't kill a fucking person and then pretend you was crazy. Get your fucking crazy fucking verdict. Get sent to the Colorado State. You should be behind bars for life. You took an innocent life. That's life in jail. That should be first degree, class 1 felony, life in jail. Instead, he gamed the system, just like Audrey Burroughs is trying to do, or his fucking lawyer, Lipka, committed to the Colorado State Hospital at Pueblo. For what, 6 months? So that's what Audrey Burroughs is going to try to do? Oh, he's a serial killer, killed 5 people. But he's pled not guilty by reason of insanity. So, was he crazy at the time? Did he do so much fucking meth? Did he rot his goddamn brain? This is your brain. This is your brain on drugs. It's just a fried egg. You're just frying an egg. So he alleged he couldn't receive a fair jury trial in Montezuma County and neighboring counties, and it'd be more convenient to the witnesses to hold the trial in Pueblo County. I kind of want to know the background to this fucking thing, because is this guy, Robert Lee Brisbin, is it clear as day that he, committed the murder? Because sometimes you can be crazy. You had that one fucking case where I'm going to assume that the way it looks like, prima facie, it looks like Robert Lee Brisbane's guilty as fuck, but he was able to game the system, trick the fucking jury. Oh, okay. Not guilty by reason of insanity. Not a self-defense plea, right? Not a police action plea, but he's fucking crazy at the time that it fucking happened. 6 months later, he's filing for a petition for a writ of habeas corpus and a motion for a change of venue. And then that's where we get our holding. So the one main holding from Brisbin v. Schauer, 1971, is that when a jury trial is granted, the right to a fair and impartial jury is a constitutional right which can never be abrogated, Groppe v. Wisconsin. And if a community is prejudiced against a citizen, or if other circumstances are likely to deny him a fair and impartial jury trial, then a change of venue must be granted, Groppe v. Wisconsin. CRCP 98, Crim P 21, whereas here a statutory remedy provides for a jury trial, and there are no change of venue provisions provided for in that statute, then the procedure to obtain a change of venue is governed by the applicable Colorado Rules of Procedure. So, blah, 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 blah. Appellant rises issue concerning the constitutionality of the statute. These issues, however, have been disposed of adversely to his position in Schauer v. Smeltzer. Colorado, the judgment is affirmed. A judgment is affirmed. So, they say that the judgment is we disagree with the judge's reasonings, but we agree with the judge's conclusion. And they happen to say this Groppe v. Wisconsin, and I'll just read a paragraph off of this here. I didn't see anything with Robert Lee Brisbin, just People v. Brisbin. Colorado Supreme Court decisions. It's probably the same thing I'm looking at right now. Case law, Brisbin v. Schauer. I wish there was more articles that talk about this. So Groppe v. Wisconsin is also a 1971 case. It's a U.S. Supreme Court case. Argued December 7th, 1970. Decided January 25th, 1971. Stuart J. delivered the opinion of the court in which Douglas Harlan, Brennan, White, and Marshall J. joined. Blackmun J. filed a concurrent opinion in which Berger C.J. joined. Post P. Black J. filed a dissenting opinion. Post P. So Groppe v. Wisconsin. Do we want to hear anything about it? All right, let's click on case. Let's just one paragraph in the middle, at the end, in the middle, right here. Footnote number 6 to Groppe v. Wisconsin. We reject the suggestion that the appellant is not in a position to attack the statute because he made an insufficient showing of community prejudice. He got like 12 fucking affidavits. His motion for a change of venue explicitly asked in the alternative that he be permitted to offer proof of the nature and extent of the local prejudice against him. His motion was denied in its entirety, thus foreclosing any opportunity to produce evidence of a prejudiced community. The trial court's ruling was, of course, wholly consistent with its view that it was powerless to grant a change of venue under Wisconsin law, regardless of what showing of local prejudice might have been made. And that's Brisbin v. Schauer, 1971. You have a right to a jury trial, and that jury better be honest and good and not biased or prejudiced in any way, shape, or form.